Today we have two presenters, Novia Nichols and Judge Mack. We're going to have a discussion today on the use of mediation in mental health matters and how mediation can improve the system of providing mental health interventions and the treatment of recovery with persons with serious mental health illnesses. So I want to start with an introduction of Novia. Some of you all may know Novia or may have mediated with Novia. If you have, that's a real treat to get to mediate with Novia. In addition to being a general civil mediator, she's also a behavioral health mediation program mediator. She's an attorney, a certified Eldercare Coordinator, a frequent presenter for the Washtenaw County Bar Association on mental health, and a volunteer at the National Alliance on Mental Health, which is NAMI. Novia has firsthand experience in representing individuals with mental health needs in the courts and in mediation, and she is just always so generous with her expertise and her knowledge, and I really appreciate that. So everybody, let's welcome Novia this morning.
Thank you.
And then next, I would also want to welcome Judge Milton Mack. Judge Mack was the state court administrator from 2015 to 2020. He was the chief judge of the Wayne County Probate Court and a Wayne County commissioner. Along with all of that, Judge Mack spent his career working to improve the outcomes for justice-involved individuals who have behavioral health needs. He wrote a policy paper in 2017, Decriminalization of Mental Illness, Fixing a Broken System, that led to the creation of the National Initiative Advisory Committee, and that resulted in the establishment of the National Judicial Task Force to examine state courts' response to mental illness. And he currently chairs the Governor's Mental Health Diversion Council. So welcome, Judge Mack. We are so pleased to have you here. And thank you, Novia, for twisting his arm and getting him here. Mm-hmm. So with that, we're going to start this morning with Judge Mack, and then we'll turn it, then I'm going to say a little bit about the mediation, the Behavioral Health Mediation Services Program, and then we'll turn it over to Novia to talk a little bit more about mental health services and court-involved individuals. So I think if you have questions, you can put them in the chat, and then at the end, we can ask Judge Mack some questions when he's done with his presentation. So with that, any questions or anything before we get started? All righty. So with that, I'm going to turn it over to Judge Mack.
Well, thank you very much. Now the trick is, can I share my screen? Am I sharing it?
You are.
Wow, that's amazing. Let's see, how do I make it big? Where's that one?
Let's see, if you go under, yeah, that one.
Okay, all right. Okay, so I'm going to talk about the effective use of mediation in mental health proceedings. The idea being this would promote treatment engagement by persons with mental illness. So I'm going to talk a little bit about the long road to mediation in Michigan, and I'm going to talk about the mental health code and the problems with it. I'll talk about assisted outpatient treatment, and I'll talk about how mediation and assisted outpatient treatment go together. So, the long road to mediation. Back in 2004, the Mental Health Commission recommended mediation should be employed in order to get consumer ownership as an alternative to involuntary treatment. I was on the Mental Health Commission. This was my recommendation. The commission said, look, this is important because people with mental illness ownership of the decision, and ownership drives engagement, and that drives recovery. So it only took 16 years, but in 2020, the legislature amended the statute and provided for mediation in mental health proceedings. The way it was written, It required a recipient or his or her representative to be offered an opportunity to request mediation to resolve a dispute between the recipient and the community mental health services provider. But that wasn't the end of it. MDHHS has been resistant to mediation pretty consistently. They fear the coercive nature of mediation, which I'm unfamiliar with that particular concept. But in any event, the statute was passed, and so MDHHS issued a request for proposals for a grant to implement the new law. The grant proposal was issued on December 23rd, 2020 at 3:03 p.m. with a January 15, 2021 deadline to apply. Now, a cynic might say that that timeline was used in hopes that no one would apply, but we'll leave that to everyone's conjecture. Anyway, the Community Dispute Resolution Centers in the meantime had formed the Michigan Community Mediation Association in a very timely way, I might add. And they were notified of the grant by SCAO. They beat the deadline and they got the grant. So we're off and running, right? Well, not so fast. So MDHHS declined to include mediation in mental health proceedings under the Mental Health Code. So it took several months of further engagement. And finally, in September of 2021, MDHHS permitted the use of the grant in these proceedings. So, mental health. Serious mental illness is a chronic condition. It is not improved by short hospital stays without a connection to treatment in the community. Historically, in Michigan and most states, a person had to be in crisis or danger to self or others before he could order treatment. And then the only treatment that could be ordered was hospitalization. And if we look around, the number one reason for emergency department visits in Michigan for the last 3 years was psychiatric care, not COVID. There were between 180 and 200,000 visits in each of those 3 years, which resulted in about 18,000 petitions for mental health treatment, of which about 40% made it to the courthouse just a week later. So, and looking a little deeper, for example, in Wayne County, in the previous 5 years, there were 16,000 petitions for treatment for 9,000 people. But only 600 of those people accounted for 36% of all the petitions. And these are individuals who are admitted for a short stay, stabilized, and released into the community without connection to treatment. And surprise, they come back. We've identified the top 76 users in Wayne County. Last year, for those 76 individuals, we spent $3.5 million on emergency room use and $1.3 million in incarceration. We didn't spend much on AOT, though. We didn't spend much on community treatment. One individual had been to the emergency department 46 times. At what point in time do you say this isn't working? But the bottom line is this: the revolving door is harmful to everybody, not just the person who has mental illness. So, unfortunately, in 2018, Michigan's mental health code was amended, and we now permit earlier intervention before crisis when a person is at risk of harm. And we also provide the court can order assisted outpatient treatment. So what this means is, and I saw this on the bench for years, family members would come in and testify, and I'd ask them, well, so when did your son or daughter stop taking their medicine? It was about 6 months ago. So we all could see the train coming down the tracks. We all knew troubles brewing, but we couldn't do anything until we picked that sweet spot just before they actually hurt somebody. So it's a bad idea, and it causes harm to the individual in terms of the brain damage from untreated mental illness. So the new law is focused on risk of harm. So if a person is at risk of harm because they don't understand the need for treatment, the court can order treatment. And it's the immediacy of the risk of harm that governs whether it's in the hospital or in the community. So just for example, there was a recent case in the Court of Appeals that affirmed an order for treatment where the doctor testified that the respondent was not at risk of harm as of the hearing date. But due to his lack of insight, he would be at risk of harm in the form of drug abuse, suicide, and dementia. within 3 to 6 months. So we can intervene earlier. And that makes a big difference because a new feature of the law is the ability to file a petition directly with the probate court to request assisted outpatient treatment. There's no hospitalization in this. You don't go to the emergency department, you don't go to the hospital. And because hospitalization is not sought, the hearing is scheduled 28 days in the future. And this creates a space for mediation. So what about AOT? What is it? Well, it's treatment in the community that's led by a treatment team that helps keep an individual in treatment and seek treatment engagement. So, for example, Genesee County has the really best program so far, and they inform the recipient that a treatment team is going to guide their treatment, and the recipient is on the treatment team. They want engagement and participation. So they have about 400 people on AOT as of right now, and these are individuals who had a long history of hospitalization and incarceration. Well, since being on AOT, the hospitalization has been cut by over 70%, and compliance with treatment is at 90%. In fact, one of the remarkable data points is that for persons on AOT who are customers of the Genesee Community Mental Health System, the rate of hospitalization in 2022 was lower than the rate of hospitalization for people who were not on AOT. And that speaks to the success of AOT getting someone well in the community. So how does this fit in with mediation? Well, because we can intervene earlier, the recipient's cognition is probably less impaired, and it creates a better environment, a better opportunity to secure treatment. And that means treatment engagement and recovery. So you all know this, a negotiated outcome that includes the input and consent of the parties is far more likely to secure treatment engagement and recovery. In fact, surveys of people on AOT indicate high levels of satisfaction with the treatment team and with the judge. I can assure you that during my time on the bench, when I was entering orders for people to be involuntarily hospitalized for up to 60 days, that the satisfaction by them of my performance was not very high. So we know that the strategy of short-term hospital stays without a connection to community treatment has been a very expensive failure. And I see mediation as a viable tool in the effort to avoid repeat hospitalization and incarceration, as well as to promote the health and well-being of people with serious mental illness. And there are a number of opportunities now for this to work. The Community Mental Health, the Dispute Resolution Center organization has trained about 100 people in the area of providing mediation for these particular proceedings. The most obvious use would be if there's a petition for AOT only filed with the probate court, and then the attorney for the individual requests mediation, and it goes to mediation. So, but there are other opportunities too, because the mediation centers, as I understand it, are willing to mediate any dispute, even if it's not covered by the grant. So, for example, if you're a treatment provider and you have someone who is becoming non-compliant, rather than waiting and file a petition in the probate court, why not go directly to the mediation center near you and request mediation? And maybe you can work out the treatment plan without ever having to go to court, which would be the best alternative. Another option is for family members who have a family member who is non-compliant, and they can request the Community Dispute Resolution Center to mediate the matter. And of course, you can always file the petition for AOT and go to mediation, and you don't have to worry about the deadline. You know, for cases involving hospitalization, the trial has to be within 7 days. And theoretically, if it's AOT only, it's 28 days. But I think judges, if you're in mediation and you're making progress, that 28-day rule is not very firm because the person's not hospitalized or liberty is not interfered with. So there's an opportunity to take care of this. So we know that AOT works. We know the mediation works. Putting them together is really in the best interest of everybody concerned. So that's my 30,000 overview of the process. So I can answer some questions now, or Gail, you can take it right from there and go to Novi.
Anybody have any questions for Judge Mack? I have one. What do you think is special about Genesee County? And why doesn't everybody do?
Well, that's a really good question. They have the quality of the CMHs across the state is inconsistent.
Mm-hmm.
We have certain counties that, when this amendment passed in 2018, Genesee embraced it and embarked upon it. Most of the other counties did not. Wayne County has recently gotten on board, and they've got about 700 people on AOT. The Genesee, Ingham, Clinton counties, they're combined CMH, they are very effective. They got around 400 people on AOT as well. So we are trying to roll it out across the state, but it's a challenge. If it requires judicial leadership, then you need judicial leadership to get started. And it really takes leadership at the local level, and it takes collaboration. And it doesn't happen across the state. So we just have to do it almost county by county. We're sort of at the retail level now. We did but it's working. For example, New York is cited as the pioneer in this area. So they came up with Kendra's law, or Kevin's law, which is AOT. So New York State, they just recently put out an RFP to seek someone to study the effectiveness of AOT in New York, although they already did one study that was fantastic. And as I'm reading the RFP, I see that they have about 3,500 people in New York State on AOT. Well, we got 400 people on AOT in Genesee, Clinton, and Eaton. If New York State used AOT to the extent that Clinton, Ingham, and Eaton do, instead of 3,500 people, they have 16,500 people. So we know that AOT works. It keeps people out of the hospital. It keeps them out of jail. It helps them, it promotes recovery. It allows them to, have a satisfying life. So making it work has been a challenge, but I can say that Wayne County is doing well now. Clinton, Eaton, and Ingham are doing well, and Genesee is doing well. St. Clair County is on board. Huron County is on board, but I would say I'm not terribly satisfied with the progress made in Kent, Oakland, and Macomb. They could do better. Washtenaw, I don't know how it's going in Washtenaw, but I do know I've got a good CMH here. So, but I don't really know what's happening in Washtenaw. Part of the problem was people weren't following the law. For example, persons who are hospitalized involuntarily, they're supposed to have a deferment conference in the hospitals to plan for discharge. The hospital is required to notify community mental health of the meeting. We discovered that in most hospitals in Michigan, CMH was not invited to the meeting. So the person would sign a deferment and be released from the hospital without a connection to community treatment. And the result was they just keep on cycling through the system. Another feature is that the hospital is required, if the judge enters an order for hospitalization and AOT, the hospital is required to give 5 days notice of discharge. Hospitals weren't doing that. So, for example, in Wayne County, Judge Burton had a case where the hospital released the person without the 5 days notice, and he responded by filing a show cause for contempt against the hospital. So the lawyer shows up, apologizes profusely, and Judge Burton says, okay, what are you going to do about it? He says, well, we're going to have a new policy. Judge Burton says, well, I'll adjourn the hearing for show cause for contempt. You come back with your new policy so I can see this being done. And he says, oh, by the way, what happened to this individual? Where is he? And they said, we don't know. Well, that's exactly the problem. You don't know because you didn't follow the law. You didn't make that connection to treatment in the community. One of our challenges has been getting the hospitals on board, but we are making progress there. And so I expect we're going to have greater compliance, but a lot of the forms that are used were not updated, which is a problem. So, in fact, the court rule only got amended a couple of years ago to require that the order for AOT be served on the CMH. Well, if you don't serve CMH with the order for AOT, they don't know about it. And the statute says that when you issue the AOT to the CMH is supposed to file a copy of the treatment plan with the probate court. Nobody was doing it across the state. So there's a whole bunch of features in the statute that permit this process to work and just not being followed. So, so now we're spending our time on implementation. But I still believe that mediation is the best alternative. That the key is treatment engagement, because a short hospital stay does not promote that and will not achieve that.
Okay.
Probably too long of an answer.
I have a question about that, if I may. Just trying to understand, I think AOT sounds like a fabulous and much needed approach. I'm just wondering exactly how mediation fits into it, where, with mediation, the key is people making voluntary agreements. And is there an issue where if somebody's mental condition inhibits their ability to understand an agreement or to comply with any agreement that they make? And I just wonder what your thoughts are about that.
That's a really good question. But I can tell you that there has been success in the use of this process. Oakland County, I think, is the headquarters for the association, and a majority of the mediations are ended successfully, where the person does agree to treatment and can sort of craft their treatment. Having a mental illness which is left untreated does not necessarily mean you're incapacitated and unable to decide. So you have to, and that's going to be a case-by-case assessment. You may determine that the case is not appropriate for mediation, or you may decide that it is. I have to leave that to your discretion, actually. But Novia probably can respond even better. But she's
So I think that's a good question, Susan. I mean, it's a case by case, because I typically look at like their capacity to understand a decision by decision assessment, right? So there may be certain things they just can't do, but if they are able to tell me and indicate they're on board with treatment, and they want to follow up, then, those kinds of things, then I allow them to. But so it just really depends on what you're asking them to do, so they may not have the executive functioning for something really complicated, but for, indicating to you, like in terms of their willingness to follow up or whatever, then I almost always allow that. I mean, depending on if, how organized they are and things like that. So there's no like hard and fast rule, but just like Milt said, it's just based on the context, and really, because they have a mental illness doesn't necessarily mean that they're, not able to engage in mediation. If anything, it's actually, I find that they like it because they actually are given an opportunity to have a voice in decisions that are about them, and they're the best person because it's about their body, and having that say really seems to really enhance their outcome.
Sure. Well, that makes, yeah. I'm just wondering if there's some guidance or screening tool that mediators could use to figure this out. I know we can get into the weeds about trying to screen people for their capacity to participate, but it is a tricky issue, I think.
It is tricky, but we're early on, So I think if you think about it in terms of compliance, the experience is that about 90% of people are compliant with the court orders for AOT. And if you were to ask me what was the compliance for involuntary hospitalization, if they could get out, I think it's pretty low. So I think the success rate in terms of engagement and compliance in a mediated agreement would be over 90%.
And so one last thing, Susan, couple things I look for is, I mean, are they, during the mediation, are they consistent with their preference? You know, that's one sort of sign that I look at. I also look at are they able to, do I think they're able to understand that they're impacted by their choices? So like, you know, if you agree, you know that it means this, like, so like looking for that connection and how they just, you know, use information logically to kind of reach that point. You know, are they saying things that leads me to believe that they understand this? So.
Thank you.
Phyllis, did you have a question?
Yeah, I was just trying, I guess it's similar, not thinking about capacity to understand, but just what the mediation would be. What the goal would be for the mental health patient and family to all agree that the person would go to outpatient treatment, and everybody, and I guess to work out a plan for how it's going to happen, who's going to take the person, so forth. Is that what happens? I mean, can you describe what the mediation would look like?
That's
Well,
Novia's.
So it sort of depends. So here's one thing I think, Milt, that would make this more effective is I think when a patient opts for mediation, they should have an attorney appointed, just like we're appointed if they're in the hospital, to assist them with this process, with their rights. And I think that would help enhance the outcome of it. But it would be oftentimes the patient, maybe their attorney, if the court's appointed one or they have one. And then it's usually like community mental health on the other side. And they can bring support people. And so, you know, it could be like a petition's filed, like Milt said, for AOT, and they're in this forum to try to figure out, like, is this something that, what does this look like? Explaining to them, you know, what, you know, services the CMH wants them to do and to see if they're on board. Because the court system, as you know, is so adversarial. If we can get that out of the court system and make it more of a discussion, you know, help them to kind of, for lack of a better, buy what we're selling, like, hey, this is why we think it's good. What do you think? And really just including them in that. And then like the lawyer, I think, can point out things like if it's a if the patient is stipulated or agreeing to be on an AOT order with no hospitalization, they're not on the lien system. And so, which is a different thing than if they go through the court. That means that they're not on the law enforcement database. So for example, if they go to court, and there's a petition for hospitalization or a combination, and the court finds that they're a person that needs treatment, they're placed on this list. And so it's one thing when I'm appointed to represent people, I'll say, hey, you know, if we do this or do this, we can avoid that. So, you know, pointing out those kind of positives for them and really helping them to be engaged in that. And oftentimes they need help with like advocating things that are upsetting, like maybe it's a medication they don't think is really therapeutic, or they have lots of side effects. And sometimes, you know, CMH, they need someone to help advocate those things. And maybe in that situation, you say, hey, is there something else that they could take instead of that has that same effect for them? You know, just doing those kind of things, I think really can help the patient, and it's really most appropriate for mediation. So it's things like that. Maybe it's ACT. Maybe they're on the ACT team, which is a team, it's called assertive community treatment, and they come to the person's home a couple times a week, and oftentimes they give meds, and you know, and they make sure they're taking them, they just check on them. Sometimes it starts out like 5 days a week, and maybe the person sort of feels like that's kind of a bit much. negotiating, helping them say, well, could we try something else, or just helping them with like some of the services, I think can be effective for mediation as well, which you don't really have that option when you go to court. You don't. The judge either finds they need it or they don't. She's not going to say, or he or she, it looks like this, because she wouldn't know, he or she wouldn't know. They're not, service providers.
So Novia, you're describing, so there's court-ordered AOTs and then there's non-court ordered AOTs. Is that correct?
No, it's just court ordered, but like if they stipulate, then there's no court needed. Like they don't have to go to court.
Okay.
If they agree to what's being requested, then they can do so without having to go to court to be on that kind of order.
Okay.
It's sort of AOT, but it's not assisted. It's outpatient treatment, but not court ordered.
Okay.
And about half of the so-called AOT cases are voluntary, which means it's not pursuant to court order, which is fine. I mean, it's not a court-ordered treatment plan. Who cares? The important part is they're getting treatment. So, we think we'll see over time fewer cases being filed in the probate court, because if you get people treatment in a timely way and they're engaged with their treatment, you're not going to see them coming back over and over again.
Are all the assisted AOTs the ones that involve the court? Do all those individuals have an attorney assigned to them?
They're supposed to.
Okay.
Yeah, they do.
And that attorney would stay with them during the duration of, if they have a complaint, there's an attorney there that could assist them.
The answer is no.
That's a little different. The attorney is appointed for the hearing and can also participate in would participate in the mediation. Now, the individual does have a right to, if you're on an AOT order for 180 days, the individual has a right to complain to the court and say, hey, look, they're not doing right by me. Then the court has to conduct a hearing. And I suspect most courts would appoint an attorney for the individual at that time to deal with that issue.
Because we had one case which we mediated at the DRC, and Nancy, you can jump in here, where it was a court-ordered, the court was very involved in the AOT, but the individual did not have an attorney. And so I was just thinking that, going forward, if the client does not have an attorney, if they want to mediate an issue, they should have access to an attorney. Is that correct?
I think so.
Okay.
I think so too.
Okay.
Yeah.
Actually, I was thinking, Gail, were there 2 cases that we did, and we have not had an attorney involved in either of those cases. There have been a lot of CMH people involved in those mediations, so it has felt unbalanced, especially because, the client did not have an attorney. And my sense has been that CMH has been very defensive, so it's been very hard to reach any kind of an agreement that works for both sides.
Yeah, I think that makes it tough, Nancy, when you just have the patient on one side and then all of these other people sort of, not against, but like having a different position without someone advocating, then I think this mediation isn't being used like we really want. And I think the courts, I can't speak for the court, but I don't know why they wouldn't appoint an attorney for somebody. What I think it may be happening is, so they're on that order, they're following with CMH. I think CMH has flyers that says, hey, if you have like a dispute, you can use mediation, which is good. But then that's where, and that's probably how, it was that you guys got the case, but there's no one helping the patient.
Yeah.
Yeah.
in one of those cases, and Gail, help me with my memory, wasn't there a mother that was advocating for the client?
Well, that
And
one,
the mother's friend?
that one was a very interesting one because it was right before Judge Mack, right before this case, before the law, right before September 21st, 2021. And so this is a case that had been referred by a by a judge in Washtenaw County. And the family had worked their way through the entire due process complaint system that's part of the mental health code. And so it was actually the individual against the state of Michigan. And they, were just trying to get services, and it was.
Did it resolve, Gail?
Beg your pardon?
Did you guys reach a settlement, like a mediated agreement, or no?
No, I mean, the Attorney General was representing. And also, though, the client, the person could not get a lawyer. She tried everything to get an attorney, and she could not find one that was knowledgeable about the mental health code at this level. And she tried, she tried everywhere and could not. I wish I had known about you at that time.
And my memory says that the client was on their own to get their own attorney. There wasn't any assistance from the court system. So
and that was pre this too. So, and she said one thing that the mom said was, if we had had mediation sooner, it could have helped so much because, really everything that was driving not everything, their problem, it was communication issues that, the communication between the CMH providers, the client, the mom, just completely broke down, where CMH would say, well, I'm not going to talk to the mom because he's over 18 now, and just, it's one of the classic, if there had been proper communication, so many problems could have been avoided, and, a individual could have been served much better too. Lavana, you have a question?
Yes, just to kind of clarify for myself, I might have missed it. So mediation is only for competent patients, correct?
No.
Okay, so if they are not competent, so then it is through the person that has either power of attorney or any legal.
I would say when I say not competent, I probably overstate that. If the person has to be in a position where, as Novia pointed out, they are in a position to understand what they're agreeing to and what it means. They might not be competent to execute a will or a trust or something like that, or contract. But if they're competent to understand that they have a mental illness, or that they need treatment for it, or they ought to have treatment for it, and they agree to, for example, in monthly injections, they understand what that means, and as long as they understand these kinds of things, then they can enter into an agreement. So, but for example, a person who has a guardian could consent to mental health treatment. I think it's so much of a case-by-case issue. But on the attorney appointment side, I would say if you have a matter where there's a case pending, the person's under an order of some sort, then you want mediation, I would suggest that you contact the court and say, we're scheduling mediation and we think this individual needs an attorney. Could you please appoint an attorney to represent them at the mediation?
Okay.
And I would also think for those persons who are petitioned and hospitalized, and the hearing is in 7 days, it'd be worthwhile to consider mediating the outpatient side, even though the hospital may discharge before the 7 days go, but you could even begin the mediation process after, possibly. So I think I would look at each situation as the opportunity for mediation. It may not be there, but if it's there, I would take it every time. I mean, when I, as a judge, one time Susan Butterwick asked me to do a program with her on mediation, guardianships, and she had asked me at one hearing, so do you? Because I was saying a lot of cases to mediation. She said, well, do you send guardianships to mediation? And I said, no. And she said, why? And I said, I don't think it's effective. And she said, why? And I said, well, I guess I don't know. So the next time we did it again, and she gave me fact patterns. So I was a straight man. So I said, okay, in this case, blah, 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 what would you do? And I said, well, I'd terminate this and do that and find this person. And she said, well, here's what happened in mediation. And she did about 5 or 6 of these things. And every outcome was better than what I did. But I did what the law provides, which is not always a great thing for the future. So anyway, so I'm a major supporter of mediation. So what I would do on the bench is when the case first came in front of me, do we have a dispute here? Yes. Would you like to go to mediation? And if they said no, I'd say, well, let me explain it to you. And I explain it, and they say, do you still not want to go to mediation? We don't want to mediation. Okay, you're going to mediation. I sent everyone anyway.
Can you talk, and I just a minute longer about that, the 28 days again, but there's an order for an AOT and it's outpatient. It's not a hospitalization.
Right.
And
when you file a petition for assisted outpatient treatment, a hearing only, no hospitalization, the hearing is scheduled 28 days later. So that's a window of opportunity to explore mediation.
And that would be kind of keeping it out of the court. Is that
right.
what? Okay.
Right.
Okay.
Right. So you file the petition for AOT only, you go to mediation, you get a mediated agreement, let's say. You can decide whether or not it's going to be by court order or just voluntary.
Okay.
Yeah, if it's a voluntary, the petition is dismissed.
Okay. I think that's an area, at least from my perspective, and I being the kind of middleman between Oakland, and our center, that really isn't promoted, and that seems like a really important area.
I think I agree. I think it's a great area of greatest opportunity.
Yeah.
And you know why, Gail, I think you probably see that is because I can tell you at least from Washtenaw County and a little bit of Livingston, there's not a lot of petitions for just AOT. And I'm not sure why that is.
Huh.
Yeah, it seems as though the vast majority of petitions are for hospitalization or a combination.
Huh. Okay.
Right. People haven't gotten the message that you don't have to wait for a crisis now.
Right.
Yeah.
That's exactly right.
If you have a family member who has a mental illness and they stop taking the medicine, they start acting odd, I wouldn't wait. And it's been difficult to get the hospitals to understand the new standard. I mean, the statute used to say that to get AOT, you had to have 2 arrests or 2 incarcerations or 2 hospitalizations. That's what the law said.
Wow.
So I had a meeting with a major mental health provider in Wayne County, and the CEO, when I'm talking about AOT, says, don't you have to have 2 prior hospitalizations or 2 prior incarcerations? Now, this is 4 years after the law was changed. And I'm thinking, if the CEO doesn't understand this rather fundamental thing, then what hope is there that the rest of the staff understands?
Mhm.
So it's getting the word out, which is important.
Mhm.
And we had one county that decided to stop taking in petitions for AOT only because they didn't have a psychiatrist. Well, you have to have a psychiatrist for trial. You don't have to have a psychiatrist before trial or as a condition of filing a petition. So we had to have the state court administrative office intervene and say you can't do that. So there are barriers that are inappropriate, I would say, that need to be knocked down. So it really takes education of people who have family members with this situation. And plus the treatment providers. Of course, the treatment providers are reluctant to file these petitions because they feel it's going to damage the relationship they have with their client. But I would suggest that what they ought to do then is contact the Community Dispute Resolution Center and ask them to mediate it before filing a petition with the court. You don't have to file a petition with the court to do this.
Mhm.
That's a good idea.
Yeah,
I mean, the
maybe we can,
CDRP, you guys mediate all kinds of stuff.
mhm. Novia, maybe that could be our New Year's
Okay.
resolution.
Yeah.
We could go visit people in Washtenaw County. Any other questions for Judge Mack or comments? All righty, thank you so much, Judge Mack, and feel free to jump back in here with any comments. Before I turn it over to Novia, we thought I should talk a little bit about the DRC's role in this program and kind of how it works. As Judge Mack mentioned, the Oakland Mediation Center is sort of the central coordinating organization for the state of Michigan. And I know several of y'all have been through the behavioral health mediation services training program. So you're sort of familiar with this, although during the initial training, they didn't really describe a lot of the process as they were still sort of working that out in the early days. If you think of it kind of like the special ed mediation services program, it's sort of a similar structure to that, although special ed isn't handled by a mediation center. There's, a separate entity that does that, but it is overseen by the state of Michigan. So Oakland Mediation receives the grant from the state of Michigan for the program and then works with all of the mediation centers in the state of Michigan to implement it. So all the calls, all the requests for a mediation underneath this program has to go initially to Oakland. So the staff at Oakland will do a little bit of intake. They don't actually verify. Sometimes they have verified that the person is receiving community mental health services. So they need to be a CMH recipient in the state of Michigan. And they'll get some and just pretty high level intake information. They'll determine what county that individual lives in, and then they'll refer that to the center, the local center that serves that county. We'll receive that information from Oakland. So far, since the grant started, we've had 4 cases. We've had sort of 5, including that one that went to the Attorney General, but there were 4 cases that have been under the grant. 2 of them were not amenable to mediation. One of them, the individual wanted to, he didn't think that he needed, he was questioning the medical necessity of the court order. And that is one thing that cannot be mediated. If the AOT, describes services and says these are medically necessary services, the medical necessity of those services cannot be covered in mediation. So in that case, we were not able to mediate it. In another case, it really wasn't a dispute with community mental health. The individual had issues with his landlord. Certainly, proper housing was part of his treatment plan that was managed by CMH, but the actual dispute wasn't with CMH. So that one was one that we could offer, hey, this isn't under the grant, but we can still mediate with you and your landlord if you like. So that one didn't really fall under the grant. We had another one, and Novia can jump in on this one, as she was representing the individual, the client, the CMH client. And that one was really, should the AOT be renewed? I think that was kind of the gist of it, and some of the services. And that one, just in sort of the pre-mediation discussions, things worked out, and the issue, we didn't even have to go to mediation on that one. Novia, do you want to add anything about that one, that case?
No, it's in my presentation, but just.
Oh, okay, I'll skip it. Yeah. And the other one, that was the case that I mentioned earlier, where we did go to mediation. We did not reach an agreement. The individual did not have an attorney with him. CMH didn't have their attorney there. And he, in a lot of ways, that one was kind of a classic example of the types of cases that that come through this program, where there has been some communication broken down between the recipient and the CMH providers, whether that's about, why am I receiving this care? I have a new provider, my medication has changed, and I don't understand how and why that changed. All of those types are really good examples of the kinds of kinds of disputes that end up in the program. I should have mentioned that with this legislation, mediation is now a step in the due process complaint system that's available to CMH recipients. So anytime they have a complaint, there's a process that they go through to get their complaint addressed and resolved, and mediation is now an option that's available to individuals. So along with that, we have to do a lot of reporting to CMH to be a recipient of the money that they receive from the state for this program. Anybody have any questions about how things work locally here, or how the DRC is involved in the program?
Just one thing, Gail, that I wanted to make sure it's clear is that when a patient asks for this mediation, CMH must participate. And that's one thing I think is important, because there's a lot of times I think that maybe they for whatever reason may not be inclined. So that makes it, I think, better for the patient at least. Yeah. It
certainly helps with scheduling, for sure. Okay, well, Novia, let me turn it over to you. And you want me to bring up your presentation?
Yeah, please.
Okay.
Thank you.
Oops, hold on. There we go.
Thank you, Gail. So I'm going to talk to you about just a brief overview of the civil commitment process, as well as my experiences using mediation and behavioral cases. And so this is a question I probably get once a week, like, how do we get someone mental health help? Right. And I want to modify this based on our earlier discussion. And one thing that we can do is we can suggest mediation before we do anything. If they're amenable to that, discussing our concerns with them should be on there, right? But let's say, you know, the risk is such that it's more of an immediate risk, and perhaps, you know, we're worried about them, you know, risk of harm to self or others. So in a situation like that, then I think hospitalization makes the most sense. And so how do we go about that? So again, we would try to work with them and encourage them to present to the hospital just for an evaluation. And maybe they go, right? And you get them to go, but while they're there, they want to leave, right? Or they're not willing to follow the recommendation. At that point in time, you know, your option would be then you could file a petition for treatment. Because if you believe that they're not safe to come home, you have these concerns, that would be an option for you to ensure that this person, you know, gets the help you believe that they need. Or alternatively, as we talked, you know, again, depending on the immediacy of the risk, maybe it's they stop their meds, or maybe, you know, you've noticed despondent mood, or, you know, it could be something where you're really not sure if they need to be in the hospital, but you definitely think something should happen. Then again, you could, you know, start with the mediation. If they're not on board, you could file a petition and just ask for just a straight AOT petition without a component of hospitalization. So let's say, you know, you have somebody that you think that really needs help. They're not on board with mediation, and you can't get them to go to the hospital. And let's say you're really worried about them. In a situation like that, you can definitely go to the probate court and request a pickup order. And so what you have to establish to get that kind of order is you have to show to the court that you've made reasonable efforts to get that person to go. And so you have to show that, and you have to show why. So you would file you'd file your petition for treatment with the probate court, and then assert what your concerns are. You know, maybe they're not eating, maybe, you know, they're suicidal, maybe, you know, whatever your concerns are, explain that to the court, explain that you've tried to get them to go. And then if the court believes there's enough evidence, the court will enter an order for a pickup order. Now that order is only good for 10 days. And you might say, well, then what do I do with this? So what you do is then you would take that order to like the local police department where this person's at. And what I've done is then just coordinated with them, you know, to, you know, where the person's at, and they'll come. What they do is then once they get that court order, the police will take that person to the hospital for an evaluation. The next slide. And so let's say the person is in the hospital. Either they went there on their own, there's a petition filed for treatment. What has to be shown at the court hearing for the court to find this is a person in need of treatment? So the first thing you have to demonstrate to the court is that this person has a mental illness, and then you have to show that they meet one other criteria of the statute. Next slide. And so what is a mental illness? This is a legal definition of mental illness here in Michigan. It's a substantial disorder of thought or mood, or it could be both, that significantly impairs their judgment, their behavior, their capacity to recognize reality, or, now this is an or test, we don't have to have all of these, or cope with the ordinary demands of life. So we have to prove that. And then secondarily, we have to show they meet one other criteria. And so this is what Milt was talking about earlier, and how this was changed in 2019, because for a long time it was really reactive, right? We had to wait for that person to do something before we intervene. Now it's much more proactive. So we just have to show one of these things. So likelihood of injury to themselves, to somebody else, or they're just unable to attend to their activities of daily living. They're not eating, they're not drinking, they're homeless, something like that. Or D, their judgment is so impaired that they don't understand their need for treatment. And because of that, because of their unawareness or their lack of judgment, they pose a significant risk of physical or mental harm to themselves or someone else. And so when these petitions are filed, the court appoints an attorney to represent the patient respondent. And that attorney has to meet with them within 72 hours of that appointment, and then explain to the patient all of their rights. Here in Michigan, patients have lots of rights under the mental health code when petitions are filed. They have a right to have a trial by judge or jury. They're set. So once the court gets the petition and all the pleadings, they will set a hearing within 7 days. When it's a petition for hospitalization or a combined orders requesting combined meaning hospitalization and outpatient versus the 28 days that we talked about earlier, and that would be if you're just asking for outpatient. A patient, in addition to their trial rights, they have a right to seek out an independent clinical evaluation. That means, so let's say they're in the hospital, there's this petition was filed, they were evaluated by 2 different doctors that both opined this person needs treatment, but maybe the patient doesn't believe that's accurate. Well, they have a right, and they can tell their attorney, to have somebody that's not affiliated with that hospital or provider come in and evaluate them. Also, importantly, and this is kind of sort of speaks to mediation in a way, the patient does have the right to defer on an initial petition to treatment. And what that means is if you're their attorney, when I meet with patients that are in the hospital that a petition's been filed, I explain to them that they have the right to avoid court and agree to the treatment that's being recommended by the hospital. So oftentimes the patients in, let's say, St. Joe's or Michigan, what I see in terms of a recommended treatment plan is they like them to stay in the hospital until their doctor thinks they're ready to leave. They like them to be compliant with the recommended medication, like them to go to groups and activities while they're in the hospital, meet with their treatment team, and then almost always there's a component of outpatient once they leave. And just like Milt said, most of these hospitalizations are acute hospitalizations, meaning they're short term. So the average length of stay is probably 5 to 7 days. So it's not a long time, right? The goal is to stabilize them and then, get them home and then following up with treatment. So if the patient is, if they're on board with that treatment, then they do not have to go to court. And they can sign this form. It's called the deferral. And it basically says that they understand the treatment. This is, being recommended. They'll agree to that. And what's really, really nice about this is it's a way for the patient to continue with the recommended treatment, but they don't have to go to court and there's no court order entered. So, it's a way to kind of keep their private medical affairs as private as possible. I mean, sometimes it could be a young college student, right? That just, learning that they don't quite have the best coping skills and they're upset. Do we really want someone like that on a court order? Because once you're on a court order, you're on the lien and you're on like that I spoke about earlier, which is a database that police have to see if someone's, I think it's intended, and Milt maybe knows more about this, but the way I understand it is this list that police know about, like if you were incapacitated or had been on an order for civil commitment, it's supposed to help better protect the public as well as the police to know maybe what they're dealing with when they make a stop. But you're on these things, and so, not everybody that has an issue with a psychiatric issue requires that, right? I mean, some people might, but a lot of times they don't. So again, another big benefit of deferring, and also speaks to their engagement in their own treatment too. They have a say, they're part of it. So whenever I'm appointed, I always really do my utmost, my level best to make sure that they understand that right. And so in terms of what the duration of these court orders are, so for an initial petition, these are the 3 sort of possibilities the court has. So they can either enter just a straight 60 days of hospitalization. I almost don't ever see that anymore. It's almost always is number 2. It's it's number 3, the combined hospitalization for up to 60 days and then of outpatient treatment for 180. But again, like the 180 days of AOT is available. It's just not really sought for whatever reason. And then, so let's say the patient's on the initial order and they think oftentimes at CMH that this order needs to continue for whatever reason. Maybe the patient isn't compliant, or maybe the patient said they're not going to stop treatment when the order expires. Then they can ask for a second order, which is 90 days. And then a continuing order is for a year. And then another option, I think, for mediation, in addition to just the straight AOT petitions, are patients, I think, that are on these continuing orders. When it's set to renew, you know, that would be an option for mediation to be utilized as well. Next slide. And so as far as what can be ordered, I know we spoke a lot about assisted outpatient treatment, but it's really nice because it's really comprehensive in terms of the services that can be ordered. So it's medication, it's blood and urinalysis to determine if they're compliant, if they're at proper like therapeutic levels. There can be components of individual and or group therapy, day programs, vocational. Some patients require just more assistance with ADL, so supervised living can be part of it. Again, ACT for some that need a little bit more intensive supervision. And then also substance abuse disorder treatment and testing can also be ordered. And so as Gail was stating, I did have a case last year where mediation was just like the key to the success of this case. What happened in that case was my client was in the hospital, and I represented him then at that point, and he deferred to treatment. So he agreed to follow the hospital's treatment recommendations, which was hospitalization and outpatient. And he duly followed up with all of that, went to CMH, went to appointments, took the meds, all of that. However, that period of time for the deferral was 180 days. Well, as that time was set to expire, what happened was CMH filed a demand for hearing. Basically, it says what that means is we want a hearing, we want this person to be on an order. Usually it's because they're not compliant, which was really odd in this case because he was compliant, right? And in this case, my client had a guardian, it was his mom, and she was, you know, on board with him following up with treatment as well. So it just really didn't make sense. And so my client thought, like, you know, he was fine following up with treatment, but he just didn't think a court order was needed, and neither did I. Next slide. And so in that case, you know, we did a lot of things. I got an independent evaluation. That person thought he didn't need an order, but I had a really difficult time, despite earnest efforts, communicating with CMH, just like calls weren't being returned. They weren't emailing me. And so at that point, I was like, well, we were set for a jury trial because I didn't know what else to do. But then Milt told me about mediation, and I called Gail, and we went through the process of setting it up. And as she stated, during the mediation planning process, that really helped to kind of resolve the case, because again, there was communication issues. And, you know, I think what's nice about it too is when the attorney was involved for CMH and didn't realize some of our concerns and things like that. And because of this program, it settled. Otherwise, we were on our way to a jury trial, which wasn't, you know, was a waste of a lot of resources and time. And it, you know, my client was so happy because he felt as though like he was heard and he was part of it. So next slide. And I guess what I think like the biggest take home about behavioral mediation is this: I think it's an excellent tool to utilize in these types of cases, really, because it really helps to provide patients with a voice in their own lives in healthcare. And as we know, when patients are engaged in treatment, their likelihood of their compliance and recovery It's just increased and enhanced, which really will help them give them the best chance of success. Thank you.
Thank you, Novia. Anybody have any questions for Novia? Michael?
Yeah, I was wondering about the interface between this program and the criminal justice system in terms of individuals who might be in both, how that all works.
Yeah, that's a good question. So like I know there's a mental health court here in Washtenaw County. And my understanding of that is it's for people that are charged with criminal cases. And if they elect, maybe Milton, you may know more about this than me, if they elect to participate in that court, then they avoid jail. But then I think they're ordered like treatment and follow-up and stuff like that. So those are really, so it could be similar, right? But I think if, you know, and maybe they're on court orders too. But so the probate, these types of cases are really more like the ones that are filed in the probate court seeking help. That I think is where someone's charged with a crime, and then we're trying to avoid court by helping them get into treatment.
Now, those are the problem-solving courts. You're charged with a crime, but there are some serious limitations in the use of these problem-solving courts. First of all, you have to plead guilty. Then you have to agree to treatment. So if you're a person who's not willing to plead guilty and not willing to accept treatment, you can't get in. And only certain crimes will let you get into mental health court.
Right.
Like, for example, a crime involving violence, you can't get in. Despite the fact that maybe, just maybe, it'd be more important for us to get you well than someone who's just trespassing. So now there's bills pending to change that. But the Center for Behavioral Health and Justice did a survey of the jails in Michigan. Only 3% of the people in jails across the state were in a problem-solving court. So they're important, but they're little used. If you want to really make a difference, you have to attack on the probate side. And we got 200,000 people showing up in emergency departments across the state every year. And 18,000 are petitioned to the probate court, and roughly 1/3 of them defer. But if the deferment process is flawed, they're just going to keep coming back. So if we really want to do something about the incarceration of people with mental illness, we should intervene upstream before they get in trouble. So a mediation is even a little further upstream, which can have a huge impact, I think.
Well, I was thinking in particular with cases that are getting into diversion deflection and running across individuals who are in that situation, largely because of mental health issues, and how those individuals who aren't, who perhaps aren't even going to be charged, can get support.
Well, there is a bill pending that would, for a person in charge of the misdemeanor, if they are determined, they would be, instead of going to the forensic center, they'd be sent to CMH to be assessed as far as whether or not they can benefit from the AOT. And if they could, then a petition would be filed, and if nobody objected, they'd be placed on an AOT and the charge is dismissed. There'd be no requirement to plead guilty, for example. And if that were a possibility, then a mediation could come into play there. Let's say, for example, you've got someone who's charged with a minor crime, but they appear to have mental illness. And instead of charging them with instead of sending them to the forensic center for a competency determination, you can send them to CMH for an assessment. And if the assessment suggests a need for AOT and the person's reluctant, then you can mediate that at that time and see if you can get everyone into compliance or into agreement with a treatment plan. And then once you got the plan, it would be entered as part of the court order, which would cause dismissal of criminal charges. So we could fit it in there if we can get this bill passed. And it's a start. Miami-Dade has a pretty advanced deferment and process where they divert people or deflect. They started with this many years ago, and of the last 10,000 encounters between police and persons with mental illness, it resulted in about 100 arrests. Everyone else, they either calmed the situation down or they were referred to a crisis center. They weren't charged. And they expanded from they started out with misdemeanors, then they added other stuff. Because really, you would like people who have more serious crimes to get treatment and get well, so they don't do it again. So it's kind of baby steps, because criminal justice system is hard to change. And you may know this, but judges tend to be hard to change too.
Thank you.
Any other questions? Oh, Phyllis.
I was just wondering if the state is, I guess it's the state or maybe the counties, are going to enhance the ability of CMH to respond to these additional cases. It's been my experience that very often I will hear that the workers at CMH are overloaded with other cases and can't help. So if they're in the process that you described, which sounds so good, they may need extra help, and I guess funds to hire more people or whatever they need to increase their effectiveness.
I have to admit, I don't buy into that. Genesee County, St. Clair County, Huron County, Wayne County, Calhoun County, Clinton County, Ingham County, Eaton County, they're all doing it. And they're doing a lot of it. Everyone else is just late to the party, I guess. But that being said, I serve on the board of the Mental Health Association of Michigan, and we requested a $15 million appropriation to cover the cost of AOT for persons who don't qualify for Medicaid. And we did not get that last year, but we put it out there. In my view, a $15 million appropriation applied across the CMHs of the state would provide the additional funding we need to make sure that people who are not Medicaid eligible would be able to get AOT. Now, $15 million in the state budget isn't even a rounding error.
So that sounds like a good plan.
Oh, well, yeah. Okay, but there should be more state support for this. And I think the hospital should probably chip in. We have the Michigan Hospital Associations involved now. In Miami-Dade, the county and the hospital provide the funds to develop their program. Because the hospital recognized the benefits of them, of all these persons with mental illness not showing up to the emergency departments.
Right.
Yeah.
Now, Florida is not a Medicaid expansion state. We are. We should be able to do better than Florida easily. To me, it just takes a commitment.
Good.
Any other quick comments before we adjourn for the day? Well, I want to thank Judge Mack and Novia for joining us and for the excellent presentation and your expertise. And we really, really, really appreciate it. And so glad to have you around and on our side.
My pleasure.
So everyone stay healthy. And if I don't see you in the next couple weeks at a mediation, if anybody wants to mediate tomorrow, I've got an opening, so shoot me an email if you do. If not, Happy New Year, and I'll see you all in 2024. So thanks again.
All right.
Thank you.
Pleasure.
Bye-bye.